Okay, good afternoon, everybody. Thank you for joining us for this webinar session today on key HR legislative changes. So I'm Greg Mitchell of HR Success, and Margot is our senior consultant and my colleague. So we'll be taking you through this session today. As I said, we hope the formal presentation will go for about 45 minutes, and then we'll leave a bit of time for questions. Having said that, if there is anything that comes up during the session or the presentation that you think needs prompt addressing, then just put something in the chat and Margot or I will keep an eye on that, and then we'll address some questions as we move through. But there will also be some time at the end, we hope, for some further questions. Margot does need to head off just before the session ends at just 5 minutes to 1, but I'll still be here if to deal with any remaining questions. So just in terms of protocols, if you could just keep yourself muted just to reduce any background noise. If you have a particular question, just write it in the chat. I may invite you to unmute yourself at that point if we need to chat with you, but just to help manage the session, if you could just be on mute for most of it, that would be great. Thank you. And we've got a few people here from the Philippines joining us today, so welcome. Nice to see you, and I hope you get value from today's session. Okay, over to you, Margot.
Thank you. Let's make sure that the presentation works. It does, great. So before we kick off, I'd just like to acknowledge the traditional owners of the land on which we're meeting today and pay respects to elders past and present. We also extend that respect to Aboriginal and Torres Strait Islander people who may be with us today. So just a little bit very quickly about HR Success. You have Greg and I here. Greg and I are the business at the moment, and our primary business is around providing HR and leadership support and guidance to small to medium businesses. We have clients across Australia, and we've been in business for in excess of 15 years now. A lot of our business is based on the sorts of things that we'll cover today, so compliance related things, but we do other things as well, like, as I said, leadership work, recruitment. We do quite a lot of recruitment work, and other things, restructuring, whatever comes up in the people management space. One of the factors or key features of our business that we're particularly proud of is that we work very closely in partnership with our clients. So we get to know the people that we work with really well, and we don't operate under retainers or lock-in contracts. So it's very much fit for purpose and designed to suit the needs of the clients that we're working with. And without giving our ages away, we've been doing this for a really long time. So today we're going to go through a number of changes that came through, particularly in 2023 and in 2024. And we'll take you through each of those in sequence. Greg will take you through the introduction and the casual employment changes. I'll then talk to right to disconnect, and then he'll talk to independent contractor arrangements. And then, as Greg said, we'll go through Q&A at the end. So let's get into it.
Okay, thank you, Margot. So as Margot alluded to, there's been a huge number of changes in the workplace relations space over the last couple of years, driven by the current government's agenda. They're very big on security of work and reducing the casualisation of the workforce and all that sort of thing. So that's the intent of a lot of changes. The particular changes are predominantly under the banner of the Closing the Loopholes legislation. There's been a significant number of changes over the last couple of years. There are still further changes to come up until August 2025 at this stage. There will likely be other changes. We'll just have to address those as they come. Some of the changes that have already occurred, which don't have the time to go through in detail today, but if you do need help with any of this, let us know, of course. But there were some changes to small business redundancy provisions, I think that was in the course towards the end of last year. There's been some changes to the right of entry and rights related to workplace delegates. So those businesses, those industries that have a unionised workforce may be more impacted by those. There have been already some changes to sham contracting arrangements, which we will mention that as part of the changes we're discussing today around independent contractors. There's also been changes relating to labour hire, and there are changes coming. I think it's in early next year around criminalising wage underpayment, so the wage theft thing. So there's been a whole heap of changes. There's a few more changes to come. The things that we're looking at today really focus on the changes that came into play quite recently, as in the 26th of August 2024. So that'll be the main focus of our session today. But of course, if you do need help with any of those other things, let us know. We also have a knowledge base on our website that covers a lot of these issues. So if you need to understand some of those other changes that have already been made, take a look at that as well. So by way of introduction, like many things, when new legislation comes in, there's a bit of a feeling out process. So there's often cases that occur within the first 12 months of introduction of new legislation, which then helps to inform how things are actually going to work on the ground and how the courts might interpret different aspects of the legislation. So whilst many things are clear in relation to the new legislation, some things are not. There's still some grey areas, there's still some questions, and we need probably another 12 to 24 months to really understand exactly how all this is going to work. So that's not terribly helpful, but that's the reality of the situation. The changes we're looking at today relate to employers and employees covered by the Fair Work system in Australia. So that is, 90% plus of the workforce in Australia. So, and I obviously need to make a disclaimer. This is general information only. It's not formal or legal advice. Sometimes these things come down to very small details, nuances related to your business, your industry, the awards that cover you. So whilst the information we provide is, pretty solid, it is general information and not formal or legal advice. We're not the only people doing this, of course, and there is actually some really good resources on the Fair Work website. Just make sure you go to the government website, fairwork.gov.au, and also Department of Employment and Workplace Relations have some good information about this as well. Okay, so let's move into the discussion proper. So the first one that we're talking about is the changes to casual employment. As we said, this came into play from the 26th of August this year. And the legislation basically introduced a new definition of casual employee. And it says that a person is a casual employee only if there is an advance, and I beg your pardon, the absence of a firm advance commitment to continuing or indefinite work. So that is that there's a genuine expectation on the parties at the time of making that contract that there will not be any advance commitment to continuing and indefinite work. So that is, at the time of making an agreement, it has to be a genuine agreement to casual employment. That is, it's ad hoc, it's on as-needs basis, it's irregular, there's no certainty of ongoing employment. So that's one key requirement of casual employment. The other key requirement is that that person, by virtue of the nature of their employment, is entitled to receive a casual loading. So the casual loading is usually 25%, and that compensates for the lack of paid annual leave and sick and carers leave. Personal and carers leave. It also covers things like no redundancy pay and that sort of thing. So the two requirements under the new legislation around casual employment are that there must be an absence of a firm advance commitment to continuing in indefinite work, and the person must be entitled to receive a casual loading. Okay, so in determining the validity of a casual employment arrangement, so if there is a dispute at any time and it's referred to the Fair Work Commission for a ruling or something, the Fair Work Commission will actually look at the real substance, the practical reality and true nature of the employment relationship. So some of this, to be honest, for those of us that have been around for a while, is a bit of back to the future. That used to be the case, that they would look at the real substance, practical reality and true nature of the arrangement. A number of years ago, in response to a couple of cases, the requirements changed, and basically there was a stronger dependence on the written terms of the contract. So if the parties agreed that it was casual employment and it was documented and the person received a loading, then the court would predominantly give greatest weight to that contract and say, well, there you go, the parties decided that it was a casual contract, therefore, to a large extent, they're going to support that was a valid casual contract. Now, however, they're going back to the old model, which basically says, well, look, the contract, the words in the contract are important, but we won't be relying entirely on that. We will be seeking to understand what is the reality of this relationship in determining whether it is in fact a genuine casual arrangement. So the sorts of things that they would look at if called upon to do so to determine whether it is in fact a genuine casual employment relationship is they'd look at, well, what are the options that the parties have? So is it a true reflection of the arrangement that the employee can reject work and that an employer can offer work whenever they required, as opposed to an employer feeling obliged, okay, well, I need to give them 10 hours a week work. And the employee, if there's a compulsion on the employee generally, I should say, to accept a rostered shift, then that is not a clear indication of a casual arrangement. A genuine casual arrangement is the employer saying, okay, we're super busy today, or we're going to be super busy this week in the lead up to Christmas or whatever it is. We need more staff. Then I will offer extra hours to my casual employees. If those casual employees feel compelled, or it's the nature of the relationship that they feel compelled to accept that work, then that may not be a genuine casual arrangement. A genuine casual arrangement is whereby the employee says, well, sorry, but I can't do that this week. I'm going out with the kids or at school holidays or whatever it is. That is more reflective of a genuine casual arrangement. So under an arrangement in which the employer can offer or withhold work, and the employee can, in practice, accept or reject work. One of the other things that they would look at is the likelihood of future work being available within the business based on the nature of the business. So if for example, it's a retail establishment and you're open 6.5 days a week or whatever it might be, and you're engaging casual people to staff the store, then obviously that work is going to continue because that's the nature of your business. So, what is the likelihood of ongoing work being available? If there is a high likelihood, then again, that's not reflective of a genuine casual arrangement. Another thing we look at, the Commission would look at, is whether there are people that are not casuals that are performing the same kind of work. So we've got a client currently, for example, who's in the cleaning business. They have a number of casuals. They also have some full-timers and part-timers. So, we're talking with them about the suitability of ongoing casual arrangements for those people. And then also there's the thing about whether the person has a regular pattern of work. So, if you're engaging casuals, you should not be saying to them, well, how about you work every Monday and Tuesday? That's not reflective of casual employment. Casual employment's meant to be more ad hoc, irregular. Under the new legislation, and this is really a quite important point. I will be sharing the slides with you, by the way, after the session, so don't feel you need to copy all this down. Under the new legislation, a casual employment who is correctly engaged as a casual employee will remain casual until such time as their employment status changes, either through a conversion process, and we'll talk about how that works, or there's been a Fair Work Commission order. So under the new legislation, the Fair Work Commission can, in certain circumstances, say that is not a genuine casual arrangement. You need to put that person on part-time or full-time. They can make those orders now under the new legislation. Another way in which somebody might change from casual to part-time or full-time employment is they're offered that by their employer and they accept that new arrangement. So that's a really important part of the new legislation. So what this effectively means is that if you enter genuinely into a casual employment relationship with a person, and over time, so we might be talking about a year or 2 years, over time, that changes into an obvious part-time relationship. That is, the person has defaulted to working every Monday and Tuesday. Under the new legislation, that person genuinely remains a casual unless one of those things on the previous page happen. Okay, so that's a really important point. The fact that the relationship now very much looks like a part-time or even full-time arrangement, it doesn't matter under the new legislation. So long as at the time the employment arrangement was entered into, it was a genuine casual arrangement, they can stay as a casual, even though in reality it may look somewhat different to casual employment. Okay, so there are new requirements around conversion of casuals. So important to note that these are the requirements that are applying from the 26th of August this year for casual employees employed from that date onward. Okay, there is a transition period for existing casuals prior to 26th of August, which we'll cover in a moment. In terms of new casuals, however, if they've been employed for at least 6 months or 12 months in the case of a small business employer, and that is an employer with fewer than 15 staff, an employee that's had that length of service can notify their employer in writing if they believe they no longer meet the definition of a casual and they should be converted to another type of employment, full-time or part-time. So the arrangement is changing from what we had prior to August, which was largely an employer-led conversion pathway. It's changing from that to more of an employee choice. So if they feel that they no longer meet the definition of a casual employee, they can request conversion from of their employer. The employer, once they receive such a request, must consider it genuinely and they must respond within 21 days. And there are only certain requirements under which, certain grounds under which they can deny a request for conversion. So they relate to, well, we we don't agree. We do think it's still a genuine casual arrangement, or it might be on operational grounds or something like that. So, for example, yes, I know you've been working regularly for the last 6 months or the last 12 months, but our business is changing and we don't expect that to continue. That would be a genuine reason under which, so long as it was true, that would be a legitimate reason for denying a conversion request. If there's any dispute in regards to those matters, the Fair Work Commission now have the opportunity to manage those disputes through conciliation and, if required, arbitration. So I mentioned before that employees engaged before, casual employees engaged before the 26th of August, there's a transition arrangement in place for those people. So what are those arrangements? Until the 26th of February next year, so that's a period of 6 months from the commencement of the legislation, those casuals employed by non-small business employers, so those with 15 or more, they still need to be offered or not offered ongoing employment if they meet the criteria, which is basically have a regular pattern of work for, I think it is 6 months, and they've met the service requirements. So whilst the new model is employee choice, there's a transition period in place, which means that the previous obligation an employer has to offer conversion still applies to employees that were employed before 26th of August. That obligation on the employer to offer conversion, if they meet the criteria, still applies until the 26th of February next year. Now, the use of the words not offered is interesting. What that means is that you still need to consider it as an employer, and if you feel that a conversion is not appropriate, you still need to communicate that in writing to your employees. So whilst we're moving to an employee choice model, there are still some obligations on certain employers to offer conversion in certain circumstances until the end of February next year. So just keep that in mind if you're not a small business employer. Employees in that situation also have the opportunity to request conversion, and casual employees that are employed by a small business employer, that is fewer than 15 staff, may still request conversion until 26th of August. Now, after that time, so after the 26th of August 2025 and after the 26th of February 2025, in the case of non-small business employers, those transition arrangements will cease, and all casuals, regardless of when they commenced, will be under the new arrangements in respect of casual conversion. The further thing that's changed in relation to casual employment is the issuing of the casual employment information statement. So those of you that are employers should be aware that you need to give everybody on commencement or as soon as possible after their employment a copy of the Fair Work information statement. If they are a casual employee, you also need to give them a copy of the casual employment information statement. Now, under the new arrangements, they need to be given to new casuals as soon as possible or after the start of their employment. That's pretty much the same. However, also under the new arrangement, casual employees employed by non-small businesses also need to give the casual employment information statement to those employees 6 months after the commencement of their employment, and then 12 months after commencement of their employment, and every 12 months after every 12-month anniversary. So if you've got a casual employee that's there for a few years, you need to issue that casual employment statement to them multiple times throughout their employment period. So it's important that you keep track of this, particularly if you're a non-small business employer. so that you are meeting your requirements to issue that statement regularly. Now, if you're a small business employer, it's a little bit easier. You need to give it to them at the time of their commencement or as soon as possible after, and then you need to reissue it 12 months after their employment. But at that point, in relation to small business employers, their obligation to continue to issue the casual employment information statement ends. Just a couple of things. These things, the information statements do change fairly regularly, probably every 6 months or so. So our advice is to be sure that you're issuing the current employment information statements, which are available on the Fair Work website, of course. And given the increasing obligations to continue to issue the statement regularly throughout somebody's employment, you should keep a track of how and when they are issued to your employees. Okay, so just closing off casual employment, our suggestions are you review casual employment arrangements that you currently have in place, update any contracts if required. If you engaged casual employees prior to 26th of August, make sure that you're aware of the transition arrangements and that you meet your obligations in regards to those arrangements. And as we just covered there, make sure that you've got a good process in place for knowing when to issue the casual employment information statement to your staff and that you maintain an appropriate record of the issuing of those statements. Okay, we've taken a little bit of time on that, but that's one of the more complicated changes. I'll hand over to Margot now for the right to disconnect.
Thank you, Greg. So I will move through this relatively quickly. There are a number of things, though, that are important to point out in the right to disconnect, and there's been a lot of coverage about it, in particular in the press in recent times. So the right to disconnect is essentially referring to an employee's ability to disengage from work-related communications outside of working hours. And it's designed to protect employees' personal time and to reduce burnout. And it's become increasingly more prevalent in other countries around the world in particular, and Australia is following their lead, particularly in Europe. So what it is about is essentially protecting employee well-being. So there has been in the past a perception, at least, that people need to be constantly available, particularly given the rise in remote work in recent years. And it's really started to blur the lines between work and personal time, which is having detrimental impacts on stress, burnout, and a decline in mental health. And you've seen some of this reflected in changes to workplace health and safety laws, particularly around things like psychosocial risks. So disconnecting after work is designed to help employees recharge and to foster a healthier work-life balance. There's also been quite a bit of research done into the impacts on productivity. And there's been a lot of evidence showing that overworked employees are less effective, which kind of goes, you would think, without saying, but it's proven in the numbers. In terms of burnout and stress, there's growing awareness of this as a critical issue. And the World Health Organization has actually classified burnout as an occupational phenomenon which needs a lot of highlight and structured time off to avoid it. So as I said, countries like France, Spain, Ireland have all introduced this some years ago and are starting to see some long-term benefits to employees and to employers, particularly in terms of reduced healthcare costs. So it's being seen as both a necessity and a smart business decision. So what does the legislation say? So basically what it's saying, and it's important to be careful about the wording in this. As I said, it's got a lot of press coverage. Not all of it is 100% accurate. But employees will now have a right not to respond to contact from the employer outside of their hours, their normal hours, unless doing so is unreasonable. And we'll talk more about that in a second. So the right to disconnect will inform how employees and employers interact outside of their working hours. It does not prohibit employers from contacting employees, nor does it prevent employees from contacting each other, including across time zones. And there are a number of organizations, obviously, and of our clients who have people sometimes in multiple countries or in other states. That is all okay. Rather, the employee will be able to refuse to monitor, read, or respond to the contact or attempted contact outside of their hours when they are not expected to be working or they're not paid to be working, so long as doing so is not unreasonable. And importantly, and we'll talk about this in a little more detail as well, the right to disconnect will be a right protected under the general protections provisions of the Fair Work Act. And employers and employees will be able to go to the Fair Work Commission to seek orders on this right if need be. And I'll talk to all of those things in a little more detail in a second. It's important, and this is just one example from the SHADS or Social Community Home Care and Disability Services Award. It's important to note that the right to disconnect has now been inserted into modern awards. So if you have employees who are covered by a modern award, the clause relating to right to disconnect is going to be in there. It is a model clause, so for most awards, it's identical throughout. However, I would strongly encourage you to have a look at the awards that cover your business and be very clear on specifically what it says. And I won't go to the detail, it's far too small for you to be able to read anyway, but it's there. So let's talk a little bit about unreasonable. So there are factors to help determine whether an employee's refusal is unreasonable or not. And this is not an exhaustive list, but it gives you an indication at least. And what it comes down to is, firstly, the reason for the contact or the attempted contact. So if it is, for example, an emergency situation, then the contact may well be deemed to be reasonable. The second thing is the method of contact and the level of disruption that it causes. So this could go to, for example, it's one text message that is sent saying, I need to speak with you urgently, versus 15 text messages over the course of an hour. That may be seen as unreasonable. Again, though, as Greg mentioned with the casual stuff, this can come down to the very specific circumstances for each situation. So if you are in doubt, it's best for you, if you can, to check before you make the contact, and then before you act if the request or the contact is not responded to. Another of the factors is whether or not the employee is compensated to remain available. So certainly for those of your employees who are paid, say, above award wages or are paid in management positions, there may be a requirement in their contracts, for example, to perform additional work outside of those ordinary hours, in which case the contact could well be deemed to be reasonable again. And linking into that is the nature of the employee's role and the employee's level of responsibility. So if it is a person who is in a more junior role or an entry-level role, then they may have more of a right to refuse or respond to the contact than somebody in a more senior role. And you also need to factor in the employee's personal circumstances, including their family or caring responsibilities. So in summary, with all of that, the employee's right to refuse work-related contact comes down to the nature of it, but it becomes a workplace right. And what that means is that the employer cannot take action against the employee if they refuse to make or respond to the contact, and if that was deemed to be unreasonable. Like Greg said with the casual stuff, this is going to ultimately come down to a whole lot of case law, none of which exists yet. So it's difficult to say whether or not the specifics of a circumstance are going to be deemed to be unreasonable contact or not. So we would encourage you to exercise some caution in this regard, but we also have some tips around some of the things that you might do to mitigate some of the risks around it. So this is just some suggestions on some things that you might do. In our view, there has been a bit of hysteria whipped up by some of the media in respect to this issue. And there have been some employer interest groups that have expressed concern that employers will end up finding themselves in court if they try and make any contact with employees out of hours. That's not necessarily the case. So the reality is probably going to sit somewhere in the middle. But just keep in mind that the legislation is primarily designed to prevent those employees who, in our experience, represent a small minority, who consistently and unreasonably seek to contact their employees after hours for reasons that simply may not be necessary. So it's also designed to prevent that small minority of employees from taking adverse action against those employees who might seek or resist or ignore their employer's requests. So it's not designed to curtail the employer's efforts to manage the business. So while the guidelines will, early cases will inform this, it's unlikely, for example, that if you make contact with a casual employee in the hospitality industry to say, can you cover a shift? I've got somebody who's away because they're sick. That's unlikely to be a problem. Nor is it unlikely, in our view, if you reach out to somebody in a professional role or a senior level role to clarify something, in a tender submission that's due the following day. Again, that could be considered to be reasonable. But what could be problematic is if you, as the employer, seek to take adverse action against an employee who reasonably does not respond to your attempted contact, I should say. So what are some tips that you could potentially engage with? Firstly, look at the necessity. Before you contact somebody out of hours, consider whether it's really necessary. And if it can wait until the next business day, we'd suggest you consider refraining until then. In terms of communication, when you're communicating out of hours, consider adding a sentence to, say, your text message or an email, indicating that the employee is not expected to respond until the following day. Something along the lines of, my working hours may not be your working hours. Please don't feel obligated to respond to this email outside of your ordinary hours. That can help manage the expectations and reduce the pressure on employees to engage with any non-urgent work outside of their working hours. In Outlook, for example, you can use scheduling tools. So you can actually set up emails to go out at specific times during working hours, even if you draft them after hours. You can actually schedule when they're sent. So, for example, you're sitting at home on a Sunday night and you draft up half a dozen emails at 10 o'clock that night. You can use that scheduling function in Outlook to send them at 9 o'clock the following morning. We'd also suggest you set clear expectations from the start, particularly if you're working on, say, special projects. If you know that there's going to be a requirement for contact outside of working hours, particularly with employees in different locations or different time zones, set these up at the start of the project so everybody is clear and knows that they might expect to see some contact. Communicate with third parties. That is really important as well. So the right to disconnect equally applies to communications from third parties like suppliers, clients, distributors, contractors, and so on, as to employees. So consider how to manage their expectations outside of hours as well, so that they don't put you potentially in breach of the new rights. So that has been right to disconnect in an absolute whirlwind, but I'll hand back to Greg to talk through some of the changes to independent contractor arrangements as well.
Okay, thank you, Margot. I'm just conscious of time, folks, and hoping to leave a bit of time for questions at least. It's okay though, because I think the independent contractor arrangement changes are probably less applicable to most of the audience. So we will cover those, but we'll whiz through this pretty quickly. So, okay, so these changes also came into effect from August 26th of August. And what the legislation did was effectively introduce a new definition relating to employee and employer. And a bit like the casual definition, it now emphasises the real substance, practical reality, and true nature of the working relationship. Again, just beyond just the written terms of the contract. So I made a reference to Back to the Future in relation to casuals. It's similar in relation to this changes to contractor legislation. So from the 26th of August, the Commission, if required to consider these issues, as in whether a person is in fact a genuine contractor or whether the relationship is more one of employee and employer, they will, from the 26th of August, apply what's called the whole of the relationship test. So they look at the contract and what the contract says, but they look behind the contract to see the actual substance, the genuine nature of the arrangement. And if the contract says it's a contractual relationship, but the substance indicates it's an employment relationship, they will most likely determine that it is in fact an employee-employer relationship, which then brings a different set of rights and obligations. So what are the things that they would look at in terms of that whole of relationship test? They'd be looking at things like who has control over the work. So who decides what gets done, who decides when it gets done, and who decides how it gets done. The more that decision is in the hands of the worker, the more that is indicative of a contractual relationship. But if the manager, for want of a better term, is making all those decisions and the contractor or the worker is just following directions, then that is more reflective of an employment relationship. Other things that they'll look at is economic dependence. So to what extent is the income of the worker derived from this arrangement? Again, if it's to the extent that they get most of their income from that relationship, that's probably an indication more of an employment relationship. But again, you can't look at these things singularly. You need to look at them collectively. Integration into the business. To what extent is that worker a part of the business? Do they wear uniforms? Do they have a business card? Again, those things are more reflective of an employment relationship. What's the nature of the work? I referred earlier to the cleaning client that we have. If they are employing cleaners as contractors, then that reduces the argument that it's a genuine contractor arrangement, because cleaning is obviously integral to their business. Does the worker have the ability to delegate or subcontract? If so, then that may be more indicative of a contractor relationship. Contractors will generally supply the major tools and equipment to do the job. So you're thinking construction, a contractor, a genuine contractor, may actually come with the bulldozer or the digger or the grader or whatever it is. And who bears the risk? So if something goes wrong, whose job is it to fix it? Is it the contractor's job, or is it the business that's providing that service? So they're the sorts of things that would be looked at if required in terms of determining whether it's a contractor or an employee relationship. The new legislation also introduces some opt-out provisions. So what that basically says is that for those workers earning above the contractor high income threshold, which is currently $175,000 per year, and that's, I think, pretty much in line with the high income threshold for unfair dismissals. Anyway, workers that are earning in excess of that can volunteer to opt out of the new definition. So what that effectively means is that the old definition would apply to workers that opt out. And the old definition relies primarily on the terms of the contract between the parties, as opposed to the substance of the relationship. So there is a formal process by which that happens. The worker would need to provide a formal notice to the business that they're opting out, or the business can also invite a contractor that meets the high income threshold to opt out, and they can have a discussion and determine what's going to work best for both of them. It's important to note, though, that if there is any opting out by the worker in these circumstances, they can revoke that notice at any time, and at that point, the new requirements would in fact apply to them. Okay, this is just a reminder, really. So sham contracting, this change was actually made in February 2024, but while we're talking about independent contractors, I thought it worthy of note to remind you that there was a change to the test. So prior to February 2024, an employer could defend themselves. So if somebody said, well, hang on, if the commission, for example, said you got it wrong, this person was not a genuine contractor, the employer could use the defense of, well, sorry, I got it wrong. I didn't quite understand. I made a mistake. They've actually changed the nature of the defense and made it harder for employers. It's only a defense now to incorrectly classify somebody as a contractor if the employer reasonably believed at the time of making the arrangement that that person was a genuine contractor. So you can't just say, oops, I made a mistake. You need to have reasonably and genuinely believed that that was the appropriate arrangement. And if you're unable to do that, then potentially there's fines and penalties that can apply. So in terms of things to do around independent contractors, if you are engaging them in your business, our suggestion is that you review those current arrangements in light of the new legislation, and that if required, you update those arrangements or contracts as required. It may be, for example, that you end up having discussions with contractors about, well, sorry, but I don't think that that's a contractor arrangement anymore. We need to look at bringing you on board as an employee. So you need to have a think about that and whether you need to have those conversations. Also, if you are engaging contractors that exceed the high income threshold, then you might want to think about the opportunity of inviting them to opt out of the new arrangements. Okay, so we've got 10 minutes left or so. Q&A. So over to you, folks. Feel free to write in the chat or stick up your hand or something, and we can unmute you if required, if you have any particular questions. Oh, there's a hand up. Anil?
Thanks, Greg.
All right.
So with the contractor arrangements, if someone is working within a business and has a set fee to complete some work, and it's up to them, they may have to follow a checklist, for example, that the business has provided them to complete some sort of work. But the amount, how they go about the work and the amount of time they take is up to them, and they provide a set fee. Is that one of the considerations at all, or not really?
Yes, but it's one of multiple considerations. So, there's a list of things that you would look at, such as who's supplying the tools and equipment, who is responsible for rectification of any improper work and all those sorts of things, who bears the cost of that. So you would look at a whole range of things, but the fact that you've said, there's a bit of a checklist, a few protocols that they need to follow, but by and large, the timing of the work and all that is up to them. That does indicate some semblance of a contractor relationship. But
in that case, they would need to, if it wasn't up to standard, they'd need to come back in their own time to complete
basically
that work.
Yeah. So there's certainly some elements in what you say that I think are consistent with the contractor relationship, but you'd need to look at the totality of the arrangement.
Yep. It's very, can be tricky. Thanks, Greg.
Indeed. Okay, so we've got a couple of other questions coming through now. Okay, so Joe, right, Margot, you might get this one. Is the right to disconnect related to the new positive obligation regarding worker wellbeing?
It didn't come directly from those obligations, Joe. However, they are linked because they both relate to psychosocial risks and mental health and wellbeing and all of those other components. So one of the things that businesses could potentially do to help satisfy that positive obligation is to introduce a right to disconnect policy that's been developed in consultation with employees. We actually have a template that we can potentially provide to people if they need it.
Okay, thank you. Shaylana, I might ask you to unmute and ask your question if you would.
Hi, Greg. So what if your business model is that your business subcontracts, you employ casuals to do that work, and it's sort of on a contract-to-contract basis. You might work with the same firm but with multiple contracts, but just because you work one today doesn't guarantee that you're going to be successful in tendering for the next one, etc. And the contracts can be quite long, like they might require you to work some weekends, but definitely Monday to Friday, and you employ casuals as well, just because of that future. Does that qualify under that future? What was the words? Future and
The
continuing,
ongoing work.
ongoing.
Yep.
Yeah.
Well, look, you can have a fixed term. I mean, what you're describing to me sounds more like a fixed term part-time or full-time contract, because there's certainty of hours for a period of time.
Okay.
But of course, there's a whole host of changes came in, can't even remember when, but within the last couple of years around fixed-term contracts, which place some limitations on the renewal of fixed-term contracts. So that's something that you might want to look at.
Okay.
But I'd be happy, you've got my details, I'd be happy to have a separate chat with you, Shaylana, about that.
Yeah, no worries. Thank you very much.
Okay, and Joe's got another question here. If we have full-time or part-time workers doing the same work, we may still require some casuals for peak periods. Yes, well, that sounds fine to me. Yeah, you can have a mixture, and that's obviously the best way to manage business, of course, is to have a core group of staff that are doing the bulk of the work, and then you're managing your peaks and troughs through casual staff. So that seems like an appropriate arrangement to me.
Thanks, Greg. It was just that it was one of the considerations as to whether they could be considered casuals. That's all.
Yeah. Okay. Yep. Well, hopefully that answers your question. Okay. Sorry, Margot's gone, so I lost the presentation. But anyway, I've got it back now. All right. No further questions at this stage, so we'll move through the rest of it. Okay. There is further information and support available. Of course, I will send out the recording for this. I will also send out a copy of the slides for you so that you have those available. There's our email address, our phone number. You will receive some updates from us. Unsubscribe anytime, but hopefully you'll find those of use. And we do often share changes to legislation and blog articles and whatnot through our socials. So our Facebook and LinkedIn pages, feel free to join those if that would be helpful to you. On the issue of compliance, we also have a scorecard available, which is free to use, no obligation. It's recently been updated to reflect the new arrangements. It takes about 5 to 10 minutes to complete. and you'll actually receive a 21-page report, which I think is certainly worthwhile. People find that quite useful. It goes through all the national employment standards, contractors versus employees, superannuation, how to manage terminations, all those sorts of things. So please access that if you think that might be of use to you. Thank you also for your time. If we've got any final questions, please put them in the chat. I'll hang around for a couple of minutes in the event anybody has any last-minute questions, but really appreciate your contributions to the session today. And as I say, we'll be communicating with you further. You'll receive the recording and the slides. Please do reach out if you've got any questions. Thanks very much, folks. If you need to go, thank you again, and we hope to see you soon. If you'd like to stay on the line, I'm happy to hang about for any further questions.